Okay, well, welcome everyone to today's Cleared for Takeoff webinar. I hope you can all hear me nice and clearly. We're going to be covering the latest developments in the Indian market today. We're delighted to have you all to join us in what I hope will be an interesting and insightful discussion in light of India's evolving aviation landscape. India's deeper relationship with the Cape Town Convention and also the growing significance of GIFT City as a strategic financial hub means that it's poised to reshape the country's aviation industry and bringing the country very much closer to international best practice, opening up opportunities for various stakeholders within the market. And today we're joined by three experts who are bringing their knowledge to the table. We have Richard Williams, who's a partner at Watson Farley Williams, whose extensive experience in asset finance and cross-border aviation transactions will help us get some invaluable insight into the practical implications of these legal shifts that we're seeing. We also have Randeep Bubbra, who's also a partner at Watson Farley, specialising in aviation finance with a particular focus on emergency markets. And Randeep has been following closely the regulatory and structural changes that have been impacting the Indian aviation sector. And then Rich and Randeep are joined by Jeffrey Wool. Now, I don't suppose there's many on this webinar who don't know of Jeffrey, but for those of you who don't, Jeffrey is the Secretary General of the Aviation Working Group, which is the leading organisation advancing international aircraft financing and leasing. He was one of the principal architects of the Cape Town Convention, so his unparalleled expertise and long-standing contribution to global aviation law will make his perspectives particularly important as India moves to align itself even further within the Cape Town Convention framework. And Jeffrey's also a senior global advisor here at WFW. And on the academic side, he's currently a senior academic fellow at UNIDWA and a distinguished fellow at the Hebrew University of Jerusalem. Now, just before we start, please do feel free to address any questions via the chat function. I'll monitor this as we're going through, and hopefully we can address them either during the discussion itself or at the end of the session. The session's being recorded and you'll be able to find that on our website in due course if you wish to listen to it again, together with our first session, which was Pride and President, which discussed all things US related, including tariffs. So please settle back with your cups of tea and I'll hand over first to Rich and Randeep.
Perfect. Thanks, Alison. So I think first of all, we're sort of going to go through this in themes, and I think the first theme we're going to sort of talk about is sort of the history of a brief history, I should say, of India and the sort of Cape Town Convention. So turning to Richard, can you just sort of give us a brief snapshot of that? And it's quite a long history of sort of insolvencies and Cape Town Convention in India and some of the issues the lessors and financiers have encountered.
Thanks, Randy. Yeah, I'll do my best to keep it brief. It's one of the first transactions I worked on actually as a qualified lawyer is over 20 years ago, so it's difficult to be a bit not to be a bit nostalgic, but it was an operating lease for Kingfisher Airlines. And I think the Kingfisher Airlines insolvency and two others that we'll touch upon in the summary is still one that actually we talk about at the conferences we go to in the context of repossessions and the difficulty that some creditors have faced when dealing with insolvencies in India. And I think the Kingfisher Airlines insolvency is one that's still worth mentioning because most of the transactions that Kingfisher entered into were entered into prior to the ratification of the Cape Town Convention by India. But of course, the insolvency occurred after the ratification. So the vast majority of creditors actually involved in that insolvency weren't protected by an international interest. But I think it definitely did demonstrate how much India and the aviation market would benefit from the ratification and the implementation of Cape Town, and how much of a need there was for something like the Cape Town Convention regime to apply in those circumstances. I think then fast forward a few years, I think the next most significant insolvency was that of Jet Airways. And in comparison, relatively speaking, the creditors, when I say the creditors, I mean the lessors of aircraft and financiers of aircraft, had, arguably a slightly better experience than those involved in Kingfisher, and that's because, to a large extent, there wasn't uh, I think the insolvency officer gave up fairly quickly the idea that they would be able to rescue the airline and keep it as a going concern for very long. And so I say, relatively speaking, I think the financiers and the lessors in the jet insolvency got their aircraft back a lot quicker than those involved in the Kingfisher insolvency did. But I think there were quite a few alarm bells on that insolvency. And the two key ones being, I think, is that the lessors and financiers found that they weren't able to exercise their rights under the IDIRA as they expected to be able to do so pursuant to the terms of the convention. And also, the Indian courts decided to implement and follow the Indian domestic bankruptcy code instead of the Cape Town Convention. I think the key issue for the financiers there was that the moratorium was initially one of, I think, 180 days with the possibility of it being extended, whereas everyone had expected that if the court would have followed the Cape Town Convention, then the maximum moratorium period under Alternative A, which India selected when they were ratifying the Cape Town Convention, the maximum moratorium period would have been 60 days. So that gave a lot of incentive for people to try and fix this problem. And there were a few attempts over the years between now and the jet insolvency to pass further legislation in Cape Town in India to give the Cape Town Convention primacy over domestic law. And there were some good efforts made on that, but unfortunately, ultimately, they all failed prior to the insolvency of Go First, which occurred approximately 2 years ago. And the initial experience of lessors in that circumstance, all of the aircraft in Go First were subject to operating leases. There weren't any financiers or finance leases with Go First. The lessors had, unfortunately, a very similar experience to that the creditors did in the jet insolvency, in terms of the DGCA didn't deregister the aircraft when the lessors attempted to exercise their rights under the IDIRAs. And the court, at least initially, decided to apply the domestic bankruptcy code and that very long moratorium period of at least 180 days and subject to further extensions. Now, interestingly, halfway through the process, the Ministry of Corporate Affairs in India did issue a notice, and one of the key parts of the notice was that they provided that the domestic bankruptcy code would not apply to transactions protected by an international interest. And when the judgment in Go First came almost a year to the day of the initial insolvency application, the courts decided in favor of the lessors to a large extent, and that there were lots of points to that judgment. But I think the key parts that were of most interest to us was that the courts held that the DGCA should have allowed the lessors to exercise their rights under the IDIRAs, and also that notice issued by the Ministry of Corporate Affairs was enforceable. And so transactions protected by an international interest, including operating leases, the domestic bankruptcy code shouldn't be applied to those transactions. So I say that is a very brief potted history of I think the three most significant airline insolvencies in India going back in the last kind of 15 to 20 years. So I hope I've touched on the most important points. And hopefully that kind of deals with the history, because we're very keen to focus on the future as well, especially in light of the legislation that was passed last month. And just before I do ask Jeffrey his first question, I just want to say that thanks very much, Jeffrey, for coming on. I think we're really privileged to have you on this podcast today, because you are definitely one of the top experts, of course, on the new legislation, and you've been working very hard over the past few years with some very important colleagues in India and elsewhere in ensuring that the new legislation made it through last month, and indeed, lots of hard work going on to ensure its future success. So thanks again, and I think we'd really appreciate to hear from you now that we've had the brief history from me, how you can, if you can briefly kind of explain all of the work that the AWG have done in terms of working with all the various authorities and parties in India to help bring about the enactment of legislation in May of this year.
Thank you, Richard. Thank you, Alison. Thank you all for your time. It's a pleasure to be participating with Watson Farley on this event. I should also like to acknowledge through the ether the many people with whom we've been working, including on the ground in India, on these developments. And this is clearly a shared effort, and you know who you are. But as we're reminiscing, when Richard was probably in high school, I took my first trip to India on the Cape Town Convention in 1996. The AWG had a joint seminar with the DGCA. I still have a picture of a very young version of myself, which I am fond of, at that event. And it's really been a process from 1996 until today, and it will be, I think, for the next few more months, to put ourselves in the position where creditors can fully rely on the Cape Town Convention, both in theory and in practice. A kind of fundamental theme in looking at Indian law, compared to some other laws, Indian law has always looked pretty good on paper. The problem has really been two problems over the years. One has been the operational system, especially the court system, which is highly congested, of course, and we all know that. And secondly, the introduction of the new quote modern close quote bankruptcy in 2016, which was debtor reorganization kind of centric, not balanced against the needs of financing and balancing financing against reorganization. Those are the two overriding themes that we've been working through really since 1996. The Indian government first took the view back then that no legislation was technically needed because courts in India attempt to, and I'm putting quotes around these words, harmoniously construct and construe legislation of different types and treaties so that they work harmoniously and peacefully together. Much easier said than done. Much easier said than done. Indeed, it's impossible to do that in many instances where Cape Town has a specific rule, say a number of days in which a court would act, or a moratorium. That doesn't get easily construed with a general vague standard geared towards reorganization or the needs of the court. So that position, I think, has evolved over the years, but India sort of didn't position itself to move ahead with legislation until about a year ago. And the link between those, or that change, was explained by the Go First bankruptcy. The other bankruptcies, Kingfisher and then, as Richard said, was in Cape Town, Chet and Spice. The pattern that we saw in India was that the government would kind of work with us and respond constructively to the specific problem at hand. And getting through Jet and Spice, it was done in a very kind of practical way, but there wasn't the fundamental foundational basis of legislation that could be relied on and built upon. It was never there, and it was clear. And if you look at the AWG scoring, and I'll come to that in a second, we knew that, and we've been saying that very clearly really since 1996. So the market is a critical market. It's an important market. It's been improving in so many ways. It's one of the major markets now and for the future. But the absence of this primary legislation was sort of a gaping hole in the center of the system. And when the first voluntary airline insolvency, commenced by an airline under the 2016 bankruptcy code, the IBC, all of those latent problems presented themselves, and the moratorium period and the practical issues associated with repossession, went out 377 days rather than a much shorter period, which we'll get to later. And the instinct of those involved in the proceedings kind of came out. Richard mentioned the notification, which in theory should have ended the problem right there and then by saying that the bankruptcy code didn't apply, meaning Cape Town did. But that's not what the bankruptcy court system did. Bankruptcy court systems all around the world, naturally have a kind of predisposition towards their own rules and towards reorganization, and less sensitivity, generally speaking, to existing right holders. And that came out very clearly. It should also be just noted in this regard, and I'll be saying more later about the insolvency aspect, which is critical, and the moratorium. But the 2016 bankruptcy code in India was unique in a lot of ways. It not only created a whole new approach to insolvency, it created a whole new insolvency court system and class of professionals whose purpose it was to kind of reorganize the debtor, although interestingly and probably, I think it viewed now perhaps counterproductively in the aviation context, removed current management, making that very objective less likely in practice in a specialized industry needing specialized knowledge like aviation. But the general approach in the eyes of the 2016 insolvency system and those involved and the courts were very much along the lines of what the bankruptcy court said. So much so, and this is I think in my experience, I've not seen this parallel litigation between the bankruptcy court system and the high court system, as we saw in Go First. The case that Richard mentioned was one from the high court system, not from the bankruptcy system or the appellate bankruptcy court system. Again, it's very unusual. Usually, bankruptcy courts demand exclusive jurisdiction, and I'll come to that as we go forward. But all of this kind of came out, and so kind of the sum answer to the question really was, this process has been going on for some time. The Go First bankruptcy crystallized and made express and explicit the problems that were latent from the beginning. And the need for this came just crying out in the financing community with Go First. From that point, the AWG continued, and I won't say start to work. Some of the letters that we wrote into our government friends, maybe some of them are on this call, referred to our nearly 30 years of active work. And AWG has worked for 30 years with the government and the sector. We don't just come in when there's a problem. AWG seeks to deal things at the kind of root and the core level. And so we've been working for about 30 years with the government on this point. So, our discussions were well received. Over the years, there have been a few aborted efforts to pass legislation, and the style of the legislation has ranged from a really explicit detail on a number of points to more sweeping propositions, such as we ended up with. But when enough momentum, came, a new government came in. A government that's been kind of more commercially oriented over the years. Some new personnel came in. An excellent minister of transport, very forward-leaning, who was wise enough to mention the AWG and our index 10 times in his speech to the Parliament. So he forever gained our highest regards. But he moved forward. People looked at the Indian airline order books and the results of Go First, and something needed to be done. And that thing was the passage of legislation. And so from that point, the AWG as a whole, but importantly with our Indian contact group, there are 12 law firms on our Indian contact group, and there was an executive committee of a few colleagues. Everyone here is friendly. Ravi Nath, who creates the group, Nitin, Mary Lou, and AJ. I know you all, everybody knows these leaders, and the many other excellent lawyers on the group worked together and developed a white paper. A version of the AWG white paper is on the AWG website, a public version of it that if you haven't seen it, you should see it. There's a version of that document that we reserve for private consultations. And I'll get to a bit of the points that we're dealing with. But we've been working, for the last year on the legislation. When the legislation, finally passed, and it passed on the 16th of April, and it took effect on May 1st. It was really a high and a turning point for India. I will talk later now on what needs to be done. I would just say, and I'm ending my first question here, that the legislation did produce the document you see in front of you. The AWG adjusted its scoring from the 60s to 71, which is a very substantial increase. And again, you could find this on our website. If you parse through it, it deals with a number of the things I've said, how the legislation supplants the non-compliant judicial precedent and go first. And we made a number of changes. The last paragraph there is quite important, which says the content of future implementation rules and directions issued by the registry authority or contemplated by the bill required to give practical effect to Cape Town will be materially relevant to financing and scores going forward. And so the one point I'd like to kind of leave you with at this stage is that the bill is wonderful for the reasons I'll mention. It does explicitly call for a number of subordinate laws to be passed or rules to be passed. And it implies, and in our view, it implies that several others pass as well to really ensure that not only the theory, but the practical operation works. And we will be working with the government very closely. We already have our final consultation. We've already had a consultation meeting with them on these rules. We have a final one tentatively scheduled for September. But we are guardedly optimistic that the needed rules to implement the system fully will be in effect with immediate application, including to existing transactions by the end of this year. And I'll speak a bit about the detail. So I think I'd like to stop what we've done at that stage.
Thanks very much for that, Jeffrey. I think that's really useful to sort of set the scene. I suppose switching and focusing on the detail of the Aircraft Objects Act and the work that the AWG has done to kind of bring about these results. I think one of the first things that everyone was focused on is obviously the primacy of the Cape Town Convention. So can you just sort of briefly walk us through how that has sort of changed through the Act?
Yeah. Well, first of all, India is a system in which, absent legislation, an international treaty is subordinate to national law. That's the fundamental problem. So the treaty really could not, in theory, not just practice, in theory, without legislation, the treaty could not be relied upon in the case of a conflict. So that gave rise for the need for what we call a primacy clause. It is, after much negotiation, it is in Section 9.1 of the Act, and it says, in the case of any inconsistency between a provision of the CTC Act and any other law for the time being enforced. The provisions of the Act shall prevail to the extent of such inconsistency. The 3 points to note there is that that this clause is a very powerful clause, and it applies to the Bankruptcy Code. The Bankruptcy Code is a pre-existing law. We will all have to keep our eye out for future laws because this is one based upon time, and we have systems in place to deal with that. But for our immediate purposes, this applies directly vis-a-vis the Bankruptcy Code and all other sources of law that were inconsistent. The kind of technical question is, what does the phrase, in the case of an inconsistency mean? And the more subtle point of to the extent of such inconsistency. If you look at the white paper, AWG's white paper, in part 3, you will see a very detailed treatment of that. And we've sent this to the government. And by the way, those of you that are interested in other jurisdictions, you might just take a look at part 1, which is kind of a conceptual analytic approach to a primacy clause generally and how it deals with other law. But then it applies that to very specifically to the existing sources of problems in India, which were the moratorium under the existing insolvency and bankruptcy law, as well as inconsistencies on maintaining and preserving the asset value and anti-cram down provisions of Cape Town, which were inconsistent or could be interpreted and probably would be interpreted by a reorganization-oriented judge as being inconsistent. The IBC, the Bankruptcy Court itself, had a primacy clause, so we needed to be very clear which one prevailed. And then there are a range of procedural laws in India and jurisdictional laws which have caused problems in practice because they were inconsistent and applied in a way where they prevailed over CTC. And so we go through all that very carefully, and we say what the legal effect should be the application of the primacy clause. Look, this is a big change, and socialization is needed. And so we are spending a lot of time in India working with the court system, working with the government, working with the civil aviation authorities, explaining what this means. It is rare, not unheard of, but it is rare for a government official or a court or a judge to say, I know what the law, international laws, and I know what our national law is, and I'm just going to disregard it. That's unusual. Usually there's a misunderstanding, a lack of education, lack of information. Now we have something to really rest on. We have primary legislation, which was needed, given the treaty of the force of law. It has an explicit bankruptcy, explicit primacy clause. And so now, as far as law, de jure law, we are exactly where we need to be. We need to focus on things de facto, things in practice, and we will be doing that, and I'll be addressing some of those points later in this webinar.
Yeah, thanks, Jeffrey. I mean, I think from what I'm hearing, my sort of macro interpretation of that is that, a lot of the hard work has been done in terms of getting the legislation passed, and there are still some things that need to be done. I think you did mention further subordinated legislation as well. But I think overall, from what I can hear and my interpretation, it's overall very positive because, the primary legislation was very much needed. And I think it's rare in most jurisdictions that, just primary legislation is passed and job done. I think in nearly all jurisdictions on these kinds of matters, there's further hard work and attention to detail to be done. And I think it's great that not only do we have the attention of AWG working hard behind the scenes with, lots of lawyers in India, but also you seem to have the attention of government officials as well, and they seem to be motivated to take those further steps. I think what would be, again, from a macro level, I think when Randeep and I and others at Watson, Farley and Williams are talking to clients, be it members of the legal teams, and lessors or financiers or commercial people, I think there are generally three kind of headline issues and major concerns for them coming out of the previous insolvencies, and the things I think that they really focus on quite hard and the benefits that they look for when engaging with the Cape Town Convention, when engaging with a country that's ratified the Cape Town Convention. So I think we're going to touch upon those top three issues now, and I'll start with the first one. And we have already spoken a number of times already in this podcast about the moratorium, the period of a moratorium, and how that differs between Indian domestic law and the period set forth in Alternative A of the Cape Town Convention. If there were an insolvency tomorrow of an Indian airline, hypothetically, of course, what is the what length of moratorium do we think will apply, if any moratorium at all? Because I think the situation might be complicated slightly by the Ministry of Corporate Affairs, or at least that's what some people have suggested.
Well, let me say that I hope to be giving. I hope that I'll be able to give a crystal clear answer by the end of the year. Your question was, is there an insolvency tomorrow? This is, of course, the main issue that we're focusing on right now in practice. There are a number of moving parts on this point. As you say, the October notification, in theory at least, would say there's no moratorium. However, the primacy clause sweeps away everything inconsistent. So there's a question of whether the primacy clause sweeps away the notice. There is a strong technical argument that it does not, that the notice remains under Section 9(2)(b) of the protocol. But I think more kind of important than that is, and this is the AWG's view, we need to have a real understanding. This is maybe the most important point in the webinar. We need to have a practical and a real understanding with the insolvency community and with the insolvency judges about what is really going to happen next time. Because even if we're right, no one wants to be litigating for months and months and months, and the expenses and the fees and the time delays and the asset risk associated with that. So when on our last consultation trip, we had a meeting with the insolvency community, the judges, the insolvency leaders, and we have a process going on with them to really make sure that there's understanding and education so that whatever the moratorium period is, in theory, it is in practice. That's point number one, and we're working on that. The government even has some evolving views on this. I think it's fair to say, the range is 0 to 60. Okay, that's maybe I'll give you that as an answer. And there are a few permutations kind of in between, but the answer, is certainly no more than 60 days. And we are continuing to work on that. And the other things to note, it's not just the moratorium, it's what happens during the moratorium. The two main other points are maintaining the value of the asset and who would pay for such maintenance during that period. And AWG, again, has rules being discussed to make sure that the Cape Town Convention provision, Article 11.5, which says that the value will be maintained, which implies, at the cost of the estate, would take place during that period of time. So, and I should say the Cape Town, besides the primacy clause, there's kind of belt and braces here. Article 6 of the Act specifically refers as well to Alternative A. So if there was any doubt about that, it's been removed. So we're on very solid footing. But I think, as you said, Richard, before, work in education and socialization is needed. I'll just remind everybody on this call, especially the younger people who just take as given, that Section 1110 in the U.S. Bankruptcy Code is automatic and it will work, and you don't even think about it. It took, I don't even want to tell you the number of years it took to reach the point where we are. For many, many years, Section 1110, had problems. And so there are problems. They need to be sorted out. One of the beauties of the Cape Town Convention is it's a collective global exercise. And one of the things that AWG tries to do, and I think has been successful in doing, through our global network. We have about 300 law firms that help us around the world. Again, Watson Farley is our international counsel. We have contact groups, as we have in India, that we look to on matters that are happening there or any other country. But we have access to 300 law firms who help us. Probably many of you are on the phone now, provide us information, and we make that information available through this CTC compliance index. And maybe Allison, just go to the next slide for a second, which or I'm sorry, Allison, whoever's controlling the slides, if you could just change the slide, please, to the second slide. Again, I'm sure everybody on the call, has seen or should see AWG's website. If you've not looked at our compliance index, you should. We score every country on whether they comply, who's ratified, whether they comply with the treaty. And the treaty kind of reflects contractual expectations. And so this gives you a pretty good sense of how much you could sort of rely on your contract rights in crude terms. We score, and then we have annotations. And if you go to the next slide, I'm not going to go through these, but just as an example, this tells you the declarations they made, the choices they made. Next slide. And then we have annotations, which goes through each variable in our formula, and it explains everything material that's happened in every jurisdiction. So it's meant to be encyclopedic and comprehensive, at least as far as things that are material. I hope we're able to do that, indefinitely, but time will tell. But the one on India is extremely interesting. So that's the position on bankruptcy. You could put the slide back to the main scorecard. Probably the next one is that one, yeah. So summary there is work to be done, extremely strong foundation for such work. We are more than guardedly optimistic on this point, but we will really need to ensure that the insolvency community, the bankruptcy judges, the lawyers arguing from a bankruptcy perspective have an understanding. One of the specific rules that we're proposing is to make really explicit what happens on the key issues in bankruptcy, and we look forward to reporting back to you on that in a few months.
Thanks very much, Jeffrey. And just conscious of the time, so we might combine a couple of the questions, because I think, as Richard was saying, some of the other points that lessors and financiers typically sort of focus on when talking about the Cape Town Convention is sort of the deregistration mechanics and sort of the improvements that have been made there with the ADIRA and other bits and pieces. And along with sort of, if we roll in non-consensual rights as sort of the third heading into that as well. And just for the question that's been asked in the Q&A about subordinated legislation, we will touch on that shortly. So just give us a few minutes.
Yeah, in fact, I'm not going to even deal with deregistration. I think deregistration is fine. It was fine before the act. The problem in deregistration was the bankruptcy moratorium. So it really is a bankruptcy point, not a deregistration. There were perfectly fine rules in place from the Civil Aviation Authority that worked. There were some issues, but they're really more tied to the non-consensual issue. So I think deregistration is really not a separate, it's a derivative point by solving the insolvency issue and by dealing with the non-consensual. So I wouldn't really worry too much about that point. The final point that you mentioned is a more serious point, and it relates to non-consensual rights and interests, which has an impact on export. Under the Cape Town Convention, deregistration and export are conjoined as both available, as Cape Town remedies. Again, for now, I'm not going to deal with deregistration, but export has a link to non-consensual interest. So those of you on the phone that don't know this term, it's nice that we're using these terms so casually, non-consensual rights and interests, which was a term that we helped kind of invent when we negotiated the Cape Town Convention. But this pretty much means, preferred creditors under national law that have rights that arose, by law, not by contract. And that really meant kind of tax creditors mainly, service providers, maybe employees, maybe judgment creditors, that is other than financiers. And these are by definition, groups that were given, as a matter of policy, a preference. And so one of the hardest issues in negotiating, the hardest issue in negotiating Cape Town, is arguing here, because you're arguing with the government in a way against the government. If you're arguing about taxes, they want taxes. We're going to talk later about taxes, but it's one thing to have a treaty dealing with, rights between debtors and creditors. We all benefit, but in a sense, it's zero sum. So this has been a very tough issue, and a number of service providers, of course, are government entities. We could spend way more time than we have, so I'll be very summary in my comments here, only because of their complexity. And non-consensual rights and interests is probably the most complicated area. I'd like to make a small plug for the work that Watson and Farley is doing for AWG, kind of assessing non-consensual rights and interests around the world, which is really a really important subject. But the situation that we have is as follows: that pre-Cape Town in India, if you look at the declarations made by India, in a way, they are susceptible to differing interpretations as to whether there are very limited non-consensual interests, or through the right of detention, the hammer. Because if the government holds the aircraft and makes claims, you need to pay those, which would prevail. The AWG kind of did a deal, I guess is no other way to say that, with the government a few years ago, establishing the so-called 3-month rule. And the 3-month rule said that certain, and I'll come back to who they are, non-consensual preferred creditors would be paid for a period of 3 months prior to the bankruptcy, and during the 2-month period of the bankruptcy period. And that was meaning that the lessors would absorb that cost, and they would absorb no other cost. And that was the deal that was done, given the position of the government that they had the right to everything, including GST going back for everything. So we did a deal on that. In Go First, things didn't work out that well. The Cape Town Convention speaks to preferred creditors in the context of detention, the hammer, as being limited to those that directly relate to operational aspects. And we saw in Go First that in the bankruptcy context, a lot of non-consensual claims were made for categories that we think do not align with the Cape Town Convention. In addition, the moratorium period of 377 days then just pushed everything out. So the system, was broken in Go First. So now the legislation, what does the legislation say, and what is going to be done about this? The legislation, if you read the legislation, it's not going to jump off the page how this problem goes away. First of all, there's the question of whether the primacy clause affects the 3-month rule or not. Section 5.1 of the Act says, a debtor shall maintain and submit to the registry authority records of dues arising from or relating to ownership or use of the aircraft, and here are keywords, in the manner and form as may be prescribed. So this is one of the areas where future law is explicitly required. So if you read the text, you don't see an answer here. All you see is the debtor must give notice of dues, of fees mainly. And that is sort of inspired by, let's call it the Eurocontrol model. The AWG also negotiated a deal with Eurocontrol years, way before, Richard did his first Richard probably did his first transaction at this point. Young Richard Williams, only 20 years. I speak as an old man. But there, lessors were given notice of amounts of Eurocontrol liens. And the theory was, if you have information, you can decide commercially what to do about it. you could decide to call default, not call default, whatever. That's a commercial matter. But the biggest problem on non-consensual interests is not knowing what they are and letting them accumulate and not having ability to control them. So the Act in Section 5.1 says that will be addressed and by giving information. I'm not going to go into detail. I don't have time to go into detail, but two of the points that we're discussing with the government is how to build upon the existing electronic system that India has for a modern system of providing information on these liens, so that everyone has the information and they can act accordingly and reduce their risk. And then we are discussing a rule on export, how to operationalize that to make sure that the lessor's exposure, the bank's exposure, is strictly limited to the posted amounts, and there'll be due process and information systems to make sure they're accurate, and that export therefore will be facilitated and will be efficient. So once again, this is an area in which there was a problem in Go First. The legislation provides a very general framework for dealing with it, but this is probably the area that the implementational rules are probably more important than anything else. Since we're running out of time, I will just close my comments here by saying our implementational rules are also dealing with all the other problems that we've seen in practice, the court rules, how the court systems, how one could exercise non-judicial remedies, and the like. So I'll endorse Richard's comments. This is an incredibly positive act. Working with the government and our interactions has been equally positive. The fact that we have an open discussion with the insolvency community is extremely positive. But all that said, you really need to get things done and to tighten things up and make sure that they work. And we will be working very diligently over the next few months, hopefully by the end of the year. And I hope to report full success on the implementation. Thank you.
Jeffrey, thanks so much for that. And I think, certainly with regards to the that registration process that you were talking about with regards to non-consensual rights, I think that's a really interesting piece of the legislation. But I think we have got a few messages from some of the clients. I think they're quite keen for us to move on to one of the topics that we are very keen to cover, and that's with regards to I don't think there's much secrets anymore in terms of some of the tax notices that many of the lessors and other people involved in aviation in India have received, not just recently, but perhaps actually over quite the medium term as well. And there has been so much positivity with regards to the aviation market in India, and especially with regards to legislation, and we spent a good quality amount of time discussing, and thanks so much for the detail, Jeffrey. But we are quite keen, I think, to hear from you as to your views on what's happening with regards to these tax notices, and indeed, how is the AWG helping in resolving or contributing some kind of degree of resolution to the situation regarding these tax notices?
Well, I'd like to start by saying that first, I'd like to acknowledge the work of ALI in Ireland. They've been kind of working this issue for some time, and a number of members of AWG who have been working this issue. When we were in India last week or a few weeks ago, we actually were there during the unfortunate, we were meeting with the government when the unfortunate incident took place. We constantly kind of, with everyone we spoke, made the point, India is, the IATA general meeting was in India the week before, beginning of the month. And Prime Minister Modi kept saying, he gave a talk, he said, that the India wanted to follow really, best international practices, and really wanted, and then the minister talked about the need to be working with the aviation ecosystem. We constantly made the point that the tax system and how the tax system works in practice is fundamental. And all the work that was done in Cape Town, as great as it is, we need to deal with all aspects, and tax is very high on this list. So we are now, again, I don't want to say with, over 200 people on the call, kind of private things. Sometimes, it's more important to say those in private. But I would just say the AWG has a tax group with our members. We have a tax advisory board with the four major accounting firms. Maybe they're on the call. We will be continuing to consult with ALI and with others on this point. I would just say that it now has our complete attention. We are focusing on it. We really, frankly, we're focusing more within India on the Cape Town Convention. Until now, we are completely focusing on this issue. I think everybody on this call, or many people on this call, know that the position taken on what is an operating lease, triggering the withholding, at least under the Ireland India tax treaty, in our view, and I think in the view of most people, is not consistent with the way our industry has looked at the characterization of operating leasing. So we think the basis of the statement is not correct. I think others have said that, we're saying that. So the fundamental point is, the treatment of operating leasing is really not in line with the correct interpretation, and we're continuing to work on that. The other point, and this is, I think, maybe even more important, and this is the sense I had in the meetings, is, the government, aircraft finance, and everyone on this call has whiteboards on their, on their offices with boxes and showing transactions and where people are located. Fine. You're a government official in India, and, you don't understand the structures in government financing. There's this sense. So one of the feelings is that there's sort of potential tax manipulation because, there's an entity here, there, does a treaty apply, doesn't it apply? And by the way, we've had this problem in China as well, when we talked about was a domestic transaction, what wasn't. So there's an underlying point, and I think the AWG is going to really focus on this, which is the need to explain to the government the way transactions really work. Yes, there may be a few transactions, a few structures that go, push the envelope too far and try to take advantage of existing treaties, but 95% of them do not, 98% of them do not. So we think, and I think, having sat across the table from them and from other people, that, and I think a role AWG could play, will play, is to explain these structures and show that there is no intent here to avoid taxes. That is, there are treaties, they're being relied upon, based on good legal advice, sound reasoning. And we need to explain that all these boxes that they see in head leases and subleases, are not meant to avoid a tax. The Gift City situation, I know we don't have time to go to Gift City. There's a range of questions as to, is Gift City meant to kind of force transactions there? How do you look at transactions where airlines have set up a Gift City through tax treaties? A lot of these are technical questions. And again, we don't have time, maybe another seminar, but I think that the big point is the AWG is focusing on this point. We do think that something needs to be done. Of course, there's contractual allocations of this risk, but we think that the underlying point, is that an operating lease, falls within, the definition, whether it's more or less than 8 years, if it's an operating lease, and there should be zero tax. And we will be working with the government to try to bring about that result.
Okay, thank you. Richard, Randeep, I'd like to pick up just on a couple of questions that we've received from the audience. With both the changes under the Aircraft Objects Act and also the impact of Gift City, how are we seeing all of this affect the market?
So I think, thanks for that, Alison, and thanks for the Q&A for that. I think where we see this as really positive, right? And it's a real positive shift, particularly on the financing side. I mean, just to be brief on that, I think there's no sort of secret that within India, the airlines have financed themselves heavily through sale and leasebacks and sort of the lessor market. I think the big change that will come as a use of Gift City and the Cape Town Act, it will open up a broader pool of financing for the airlines. and those primarily being sort of the tax leasing products that people are sort of speaking about. And also, I think in time, and the devil's in the detail on this, as sort of Jeffrey's gone through, but we do see sort of capital markets transactions opening up as well, and potentially, WTCs in the future.
Yeah, thanks, Randy. But I mean, I might just like to add, I think that well, obviously the obvious airlines accepted, but due to the quality of the airlines, I think Indigo, Air India, Vistara before it was merged, and more recently Akasa. I think India has always kind of punched above its weight as a jurisdiction relative to the jurisdictional risk issues. So there has been a number of very good lessors and financiers that have supported those very good quality airlines. And I think we do, Randy and I, I'm sure Jeffrey and others within Watson Farley Williams speak a lot to people that as yet haven't really done any transactions in India and now really see the passing of this act as opening almost the gateway to them being very serious about doing business in India. And I think the Indian airlines will need it because of the volume of deliveries they have. And I think it's a contradiction in terms of, because you can't be in aviation at the moment without being in India, given the volume of aircraft that will be going into India over the next a decade or so. And so there's definitely opportunities for new entrants, and I think there's most definitely, although it will lend itself to increased competition for the existing financiers and lessors. Because of the increased volume, there's just a bigger pie for everybody to share into. But I think the people that we've spoken to as well that are already in India, there will still be a need for new entrants to leverage off some of that insider knowledge and experience, quality experience that the existing people have. So it's going to create opportunities, I think, for the existing players as well. And whether that's financiers having a bigger pool of other financiers to syndicate to, or existing lessors also having a bigger pool of other lessors to trade with, and trying when they're, especially when they're trying to manage their balance sheet. So I think the way that people see things nowadays is that increased opportunity might increase the number of competitors in the market, but a bigger pie is best for everybody, and more opportunities is a good thing. And definitely with all of the developments in India, I think over the last year or so, not just with the Cape Town Convention Act, but the development of GIFT as well. Undoubtedly, there's a lot more opportunity for everybody, whether you're in India already or whether you plan to be there soon.
Great. Thank you. Thanks to all of you for taking the time to join us today. We're really grateful to Rich, Randeep, and Jeffrey for sharing their expertise and interest in the subject matter. Hopefully, this last hour or so can help us all better understand the opportunities and also the challenges that the developments in India have presented for not just India itself, but also the broader aviation industry. For us, staying informed and engaged with all of this sort of information is absolutely essential in our practice. We hope that you found the session helpful and insightful. If you've got any questions, then please do reach out to either me or any of our speakers once the session has finished. We have tried to cover off in the chat some of the questions we've received, but if we didn't quite cover anything, then do let us know. Thank you again to our speakers, and please do keep an eye out for our next webinar in the series. I think after the last one, I teased you with the next one being sense and sustainability. We didn't quite get around to doing that one due to schedules, but that should be the next one up. So have a great day. Thank you to our speakers, and thank you to you all for joining.